Welcome, everyone, and thank you for joining us. My name is Giovanna Gassage, and I am the Chief Librarian here at the United Nations Library in Vienna. And today we are very happy to have with us Sławomir Redo, who I'm just going to tell you a little bit about him. Sławomir is a visiting professor of United Nations law and a member of the UN Studies Association. He's also a former UN senior crime prevention and criminal justice expert and was formerly staff at UNODC. He's since retired. He served at the UNODC field office in Tashkent in Uzbekistan, and upon his return from there, continued to work on the implementation of UN crime prevention and criminal justice standards and norms in the Division of Operations. As a visiting professor of the United Nations law, he has been a university course lecturer on the UN and crime prevention and the UN and war crimes prevention for students in Austria, China, and Poland. He's published over 80 articles, 5 books, and co-edited another 5 books. And several of those books are in our collection. So if any of you are interested in borrowing them, please feel free to let us know. Altogether, his body of work comprises almost 300 contributions. So a very impressive set of academic output. I want to tell you a little bit about today's talk because usually we would do the talk live. Sławomir has not been feeling 100%, so we have a pre-recorded talk that I'm going to try and play. I'm going to ask any of you that have issues with the recordings to tell us so in the chat. If there are issues, then Sławomir will be presenting live, but his voice is a little shaky, so we shall see. I also ask that all of you joining us, if you have questions, please put the questions in the chat, and then Sławomir will address them after the session in the last 15 minutes. This session will be recorded. It will go up on YouTube. So if you want to revisit it at a later point, you will be able to. So without further ado, let me first let Sławomir introduce himself, and then I will try and play the recording. Go ahead, Sławomir.
The colleagues, the Giovanna, the friends of the UN crime program. I was really surprised with the invitation when a few weeks ago I visited the library, and I always go to the library at the Vienna International Center at the UNO library to see what's new, and there I saw also books of other authors with whom Giovanna Gassage, the library staff, made earlier interviews. So the reason we are here today is just exactly this, that a few books of mine were also are also in the UNOF library at the VIC, and we decided to speak sort of across the texts across the contributions to these books, rather about only about one book, one or the other, simply because I think that we should move on, especially as far as the question of the rule of law is concerned. That to me is a bit sort of underestimated in the way in which technical assistance, technical cooperation across the world addresses it. And I will only speak about the UN part of it, and even less than this, but perhaps this will give some kind of an idea what can one do about the rule of law if one wants to enhance criminal justice through the UN win rule of law operational activities. So that's the reason I'm here today. Thank you.
Ladies and gentlemen, dear colleagues and friends of the United Nations Crime Prevention and Criminal Justice Program, thank you for your invitation, dear Mrs. Gossage, to give the author's talk. I would like to start with two short definitions and one longer caveat. Regarding the definitions, by a broad term, operational activities, I mean operational activities for development. By a narrow term, technical assistance, I mean support and advance process aimed at developing the capacity of governments to formulate and implement policies for sustainable economic and social development. This is the UN interpretation of these terms in which advancement and development I would like to emphasize. So regarding the caveat, I will talk only about the UN win-win operational activities, not about activities of other donors, because technical assistance is a substantial global industry in its own right. And within that right, the operational activities are distinctly different of the UN from those of various Western or Eastern donor countries, whether or not they act independently or in concert with one another. The role of single donor countries, especially in the colonialist and early post-colonialist time after the Second World War, would require another approach and talk. In this talk, I will only focus on the role of the UN as a benevolent conqueror for development, to use this phrase from one academic publication. By focusing in my talk on the UN operation activities for win-win rule of law outcomes, I'm simplifying that UN role and the impact, because in the UN there are about 40 agencies and entities, which in some 150 developing and conflict-affected countries are engaged in providing rule of law assistance. That assistance is only partly financed through the UN regular budget, which allows for a fully fledged orchestration of the rule of law goals, while the extra budgetary assistance carried out by the UN through the earmarked funds usually has many strings attached to it. I'm sorry to belabor the obvious. I will not speak about technical assistance as a form of malevolent predatory conquest. They are on the agenda of the UN Security Council and Human Rights Council, which debate the situation in the Central African Republic. You may therefore want to refer to the 2022 Human Rights Council Resolution 51/37 adopted without a vote on technical assistance and capacity building in the field of human rights in the Central African Republic, which also addresses corruption and the independence of judiciary, and to the UN press releases summarizing very heated exchanges at the Human Rights Council regarding the human rights situation in that country. By the way, also without a vote was adopted at that session the Resolution 51/5 on the role of good governance in the promotion and protection of human rights, and Resolution 51/14 on the role of prevention in the promotion and protection of human rights, the rule of law, and accountability. So I made a number of voted and divisive resolutions important for development, like the right to development and the promotion of democratic and equitable international order. To be clear, there is a body of consensual legal instruments supporting technical assistance for the rule of law. With this rule of law consensus in mind, and in keeping with genuine developmental assistance, I will be speaking only about the UN aspects of it, not by other technical assistance providers exemplified in this slide. There are some sources estimating that globally such developmental assistance could be as much as 25% of total aid, or $40 billion annually. So while the 2023 entire UN's regular budget is $3.4 billion, and the UN regular program for cooperation amounts to merely 15-16 million US dollars. This makes about 0.6 of entire global technical assistance, within which only a fraction would be for the UN rule of law technical assistance. The UN draws only a thin blue line as far as the rule of law is concerned. So because of these estimates, my talk idealizes and exaggerates the realities of UN technical assistance. But as urban legend holds, Aristotle, not that Aristotle, but Aristotle Onassis, a Greek shipping magnate, and do not mix this with a shipment magnate, once said, during our darkest moments, we must focus to see the light. And the UN, since its establishment, has been showing that light. In this way, the UN still remains a beacon. The golden rule, do unto others as you would want them to do unto you, has many expressions in various religions and philosophies. This circle on the slide shows them and may symbolize the interfaith essence of human morality anywhere in the world. This latter interpretation may reflect also the agenda of the Vienna-based coalition of faith-based organizations. Yet, from the UN secular perspective, the Golden Rule has been formally expressed as a spirit of brotherhood in Article 1 of the Universal Declaration of Human Rights. As the preparatory works on that declaration document, the secular ecumenical expression was eventually adopted by the drafting committee on the recommendation of the Chinese delegate, and it may express universality of human kinship's benevolence. As you know, this idea has received in the UN its artistic expression when in 1984 Nancy Reagan, the wife of the US President Ronald Reagan, donated to the UN headquarters in New York Norman Rockwell's mosaic, do unto to others as you would others do unto you. Since a poster with that mosaic looks in the VIC building as if it weathered, of course, tongue in cheek, I hope that the VIC building's management colleagues will take care of that. I want to refresh the image of the Golden Rule in a conceptual way. So hopefully such nowadays also a politically weathered Golden Rule of universal benevolence will be reinvigorated in contemporary West-East, or better, global North-South technical assistance terms, including South-South terms. With that universality in mind, I will begin with 3 practice-guided recommendations regarding win-win. The first recommendation comes from the 1940s book by Antoine de Saint-Exupéry and reads, "As for the future, your task is not to foresee it, but to enable it." I found this recommendation as a motto on the paper by Professor Derek Law, submitted to the World Library and Information Congress, organized by the International Federation of Library Associations, with the topic Vision 2020, Innovative Policies, Services, and Tools. From that first recommendation, as of 2023, I took that the task of the UNODC and the Chief Librarian and the United Nations Office at Vienna is to enable the implementation of SDG 16, Peace, Justice, and Strong Institutions, which among several targets in Target 10 recommends to ensure public access to information and protect fundamental freedoms in accordance with national legislation and international agreements, and in Targets 16.3 and 5, respectively, that recommend the promotion of the rule of law and countering bribery and corruption. The second recommendation reads, "Leadership is the art of getting someone else to do something you want done because he wants to do it." The second recommendation is a paraphrased 1950s statement of one of the forerunners of the United Nations, the US General Dwight Eisenhower. But I add to that saying that the UN technical assistance leadership shows how to do it. I must also qualify his statement by adding that Eisenhower meant that such a leadership is not because of the position of power or authority compelling someone else to. Coincidentally, the UN hardly has the power to compel anyone to do something unreservedly, and nowadays seems not to be trusted enough to say that it stably enjoys a high moral authority. But no doubt, the UN has a legitimate mandate to exercise leadership in a pluralist world. So the paraphrase, the saying reads, the UN technical assistant leadership is the art of getting someone else to do something you want done because he wants to do it and the UN may show how to do it. The last recommendation regarding win-win comes from Mitchell Sharp. In the 1950s, Canadian Deputy Minister of Trade and Commerce. He was a statistician and economist concerned about the goals of his country's technical assistance. That was the time of self-determination of African peoples, in which Canada and the majority of other UN member states have emphatically and instrumentally pursued that goal through the UN. In 1961, he said, I quote, there is one good and sufficient reason for international aid, and that is that there are less fortunate people in the world who need our help. But then he added, if the purpose of our aid is to help ourselves rather than to help others, we shall probably receive in return what we deserve and a good deal less than we expect. In other words, he questioned utilitarian aid that first of all benefits a donor country, one winner only. In this sense, technical assistance is self-serving, is rational, but not reasonable or balanced. It draws its base exclusively from a sovereign state, in this case donor state, with its own public ethics or public morality, not concerned with the interstate ethos, that is, international law, customs, or attitudes and values. In short, internationally, in the ethos sense, justice is not fairness. This is then a very narrow understanding of justice limited to a donor country, which serves in fact injustice to a recipient country. In short, for justice to prevail across the world, there must be some more progressive approach how to do it. So let's make a tour of horizon. The UN technical assistance officially has begun with the first UN General Assembly resolutions adopted on the 4th of December 1948. That was a week before the adoption of the Universal Declaration of Human Rights. Then, the declaration by its preamble made the rule of law a legal concept to counter tyranny and oppression, while in Article 1 it has its golden rule recite that people should live with one another in a spirit of brotherhood. Since 1945, there has been some 230 General Assembly resolutions containing the term rule of law. But in the text, there was no explicit use of the phrase win-win. To my knowledge, officially, that is, by one or another United Nations resolution, it has not been formally combined with win-win as a mutual benefit and mutual responsibility for both recipient and donor countries. Some of the earliest technical assistance work centered on filling capacity gaps in newly independent countries by training staff and helping to establish and equip government agencies. From the 1980s onwards, technical assistance program recognized that capacity building was not just about skilling up individuals, but also addressing wider organizational and institutional constraints. Expansion of public administration, machinery, and personnel was taken as the state assumed and accelerated development tasks, focusing on achieving results, but not on minimizing related costs and thus achieving efficiency. That phrase that win-win phrase gained traction in the UNDP technical publication, starting apparently with the 1980 press release that the UNDP seeks to promote a win-win situation in which both the recipient and the donor countries gain from the exchange of knowledge, skills, and experience. End of quote. The UN crime program technical assistance has started in 1970 with prison reform projects, so more than 2 decades after the first General Assembly resolution started its program in public administration. 70 years after the Universal Declaration of Human Rights in 2018, when the General Assembly in the Global Compact for Orderly, Safe and Regular Migration in Resolution 73/195 eventually defined what is the rule of law. Since then, the win-win and rule of law, both concepts have become evidently and truly meaningful for operational activities. But even now, when the definition of the rule of law is in the UN intergovernmental books, the rule of law remains a complex and in some respects uncertain concept. To quote, or to use the parlance of the 2006 report of the UK House of Lords Select Committee on the Constitution. When it comes to the result-based management of the 2030 agenda, the UNODC handbook stops short of recommending any theory. It quite rightly informs in the caveat that any theory, be it win-win or not, any theory of change is as good as its delivery. So a project developer and manager may also draw from any other instrumental approaches, among which, of course, game and decision-making theories may have already been pursued. In my talk, I will limit myself to just one such a theory, which one may operationalize because of its close relevance to the roots of the UN and to the current SDGs. In this sense, I'm sympathetic to this approach on the basis of its merit, even though that would be against the original ideas, which led me to what I am going to say now about cooperative outcomes, the original ideas of one theorist. It may be enough to read out here that according to the 2006 World Bank report, John Rawls laid out philosophical foundations on inequality of opportunity, and read out the UNODC opinion that he developed the most famous thought experiment in philosophy. And I quote this opinion: the lecturer wraps up the session with a brief explanation of the original description by Rawls, and then explains to students that they have just had a personal experience of one of the most famous thought experiments in philosophy. I have been studying that experiment and teaching students about it at my courses on the UN and crime prevention, but for the purpose of this talk, I have gone beyond the UNODC kudos and reconfigured the operational approach to access to justice as per that thought experiment. So now I will try to unwrap how his thought experiment of the veil of ignorance made me personally think to go into the SDGs Foundation on Inequality and Opportunity, combined to recommend a new justice assessment by a field project of countering corruption. I wonder if you, as experts and other practitioners, may think about countering corruption and strengthening judicial integrity, the latter in the way recommended by the UNODC, but in field projects, not as explained to university students. Well, with this aim, I will draw on John Rawls' theory of justice, a very conceptually reinvigorating invitation to systematize our approach to access to justice. I will try to show a common language of justice which goes beyond the one which the UN started preaching for interagency cooperation when, in 2004, with this idea in mind, Kofi Annan submitted to the Security Council his first report on transitional justice and peacekeeping. Per analogy, I would like to encourage ourselves to break away from the silos thinking on a broader scale. Professor Leila Sadat, Egyptian international scholar and advisor to the International Criminal Court, has demonstrated how much Rawls' thought experiment is a real game changer. She asked, what system would protect us if we were born in a different place and time, and unlucky enough to have been Jewish during the Holocaust, Tutsi during the Rwandan genocide, a wearer of eyeglasses during the Khmer Rouge regime, or a Masalit or full tribe member in contemporary Darfur, Sudan. If we would not have this veil of ignorance and we would not have put ourselves in the shoes of these victimized groups and people. As you see, this is not an academic question. Two facts make his approach as grounded in realities. First, Rawls was an US Army soldier who visited Hiroshima after its destruction by the atomic bomb. Hiroshima was a totally obliterated city. It had no physical infrastructure, with the even more horrific human toll resulting with wiped out fabric of social institutions laid down over many generations. So, by the veil of ignorance, he meant erased physical and social infrastructure as a ground zero. Second, he was instructed by his superior to discipline a fellow soldier. Believing no punishment was justified, he refused the superior's order. Rawls was degraded, and must have affected him so much that he normatively committed himself to start working to ensure that a better society may emerge. Hence, his subsequent original position with the veil of ignorance. A zero ground, original position, a veil of ignorance. Ladies and gentlemen, this is the ground on which the UN was established in 1945, when its framers yearned for perpetual peace, and Jean-Jacques Rousseau, Confucius, and Immanuel Kant, of course, were their philosophical progenitors. So, in Rawls' terms, Professor Sadat advised to look away from all project developer comforts and recommended to assist in accessing justice in the least developed countries, as if a foreign technical assistant made a local residence assessment, and as if that assistant, who put himself in the shoes of a local resident, starts off from square one. In short, and again, as if he or she were unfortunate enough to have been Jewish during the Holocaust, Tutsi during the Rwandan genocide, a wearer of eyeglasses during the Khmer Rouge regime, or a Masalit or full tribe member in contemporary Darfur, Sudan. End of quote. For a project developer, then, justice as fairness requires to start with a professional assumption of a clean slate. So without any preconceptions, what is or may be needed to advance access to justice, as if we were locked. Recalling my own field experience, I had an idea of assisting one country in reforming its police force according to very successful police reform in my native country. Of course, I was wrong. So interests, own preferences, advantages and disadvantages initially should not matter, nor it should initially matter how the project would end up, at least as long as such a bare bone justice needs assessment is completed. As if we were locked behind the screen of ignorance, we then may come up to the conclusion that we should be treated equally because we are morally equal. If we so look for a justice system that balances out the advantages and disadvantages of nature, then we find two guiding principles. The first principle is that we all have the same fundamental rights and obligations, and that we should also exercise as much freedom as possible. The second principle is that we may accept inequalities, and they are just and fair, but as long as those worst off or left behind will be materially better off, then they would be under strict equality. In short, there is an optimal goal point A between donors and recipient's maximum advantages or shares, minimized by the upper hand of the former of the latter, that is, of a donor of a recipient. This is so-called Maximin rule. In the name of mutual continual betterment, it is in the enlightened donor's interest to address that model Maximin point by a field evaluation of recipient needs and look out for joint advantages relative to one another through an array of analytical and assessment tools for 17 goals with 169 targets and 247 indicators from the interagency and expert group on SDGs indicators. Also, involving synthetic indicators available through UNDP human development reports. Since the sky is the limit for human greed, that's what at least Isaac Newton once said, the result will never be absolutely perfect and satisfactory. This is what Rawls called a reasonable advantage. It invigorates a social way of calculating of and arriving at mutual benefits as a common good. Through win-win education and training, a reasonable mutual advantage can be worded out within the floating range of SDGs and post-SDGs values, in which the worst of those left behind benefit most in this point A. Regarding the equivalence of benefits, Aristotle, the real Aristotle, noted that there is no absolute number of shoes made by a shoemaker that equals the value of a house constructed by a builder. This is because reciprocity, I quote, is very inexact when it comes to benefits and very exact when it comes to evils. So what the work is the UNODC on drugs and crime, especially on penal policies, that's this second part that relates to the quote of Aristotle. Because reciprocity is very inexact when it comes to benefits and very exact when it comes to evils, we cannot expect the same degrees of evidence in moral and in mathematical sciences. This is what Hugo Grotius said, one of the founders of public international law in the 17th century. But also Confucius is right, who said in Analects that reciprocity with respect to benefits is perpetually relative. From him comes the idea of scaling and weighting, Quan. So that's what the master said concerning the perpetual relativity of benefits. So what we are now at this point is that this difference principle spelled out as the second principle in Rawls is in the interest of mutual advantage or mutual benefits, hence of win-win. And this is its functional equivalent, the UN Solidarity Principle from the 2000 Millennium Declaration and the 2030 Sustainable Development Agenda. And it reads, reduce inequality within and among countries by assisting those who suffer or who benefit least and deserve help from those who benefit most, so no one will be left behind. This UN solidarity principle is in the interest of mutual advantage or mutual benefits. Those better off share them with those worse off under the condition that the latter will eventually motivate themselves to overcome to some extent their material disadvantages, hence both sides will win and move on with their own advancements. So how one can operationalize the UN solidarity principle? To show this, and because of African continental Ubuntu legal culture, to see oneself through others, so is the sense of the golden rule and win-win. After all, I would like to apply in a model way that solidarity principle to counter corruption in judiciary of a fictitious country, which I named Ubuntu, exactly from Ubuntu legal culture. Imagine that there is in Ubuntu its high court justices apparently bribed, so hold civil society allegations, and they render rather lenient sentences to business persons, executives, company owners, etc., involved in money laundering of their own illegitimate financial profits, later stashed abroad. That imaginary country has a democratic system reaffirming that human rights, the rule of law, and democracy are interlinked and mutually reinforcing, and that they belong to the universal and indivisible core values and principles of the United Nations, as many resolutions of the Human Rights Council and of the United Nations General Assembly say. So that country has a constitution with a tripartite division of powers, hence independent judiciary. But the country's people, especially those with university education, emigrate to the New World and to the Old Continent because they see no life chances because of the immensely corrupted environment. They don't want to stay put. Corruption thus involves not only the judiciary, but the whole network of providers of falsified documents, legitimizing travel, if not a plain migrant smuggling. Hence the question, what can be done in technical assistance terms to help to reverse this trend and restore the confidence in the country's lot so the most educated not only become immune to corruption, high court justices, for example, but civil society and other concerned groups and single people will find the country's anti-corruption efforts worth of giving a try for a sustainable livelihood. This figure shows 4 process-to-product elements for a UN rule of law upcycle into regional sustainable development anti-corruption outcome. It invites or induces consensus for cooperation and makes reducing inequalities as the G10 as the tangible process. The figure consists of 4 elements. The first constitutes a particular moral issue, for example, corruption of the judiciary. The second element compromises local, everyday, and general ethical principles, tolerance of corruption, and calls for no bribery. This matters because such genuine calls for no bribery can either be formulated bottom up, as coming from the civil society, or top down, as coming from the government. Any donor must take one or another approach into account and appropriately configure its own input into the anti-corruption strategy or project, so as per Rawls' idea, these 2 first elements, that is moral judgment, and those external principles, that is number 1 and 2, become mutually reflective and workable. These 2 elements are also modified by the third element. It comprises academic universalizing theories. For example, general social theory, theories about the nature of a person, of origins of corruption, including considerations whether or not one accepts corruption as a way of life, ways of thinking, corruption as a moral or immoral conduct, as a way to go, set of beliefs, or as a contradiction to a social contract. These 3 elements lead to the so-called considered judgment, in Rawlsian terms, that is, to the 4th element. It reflects a coherent progressive normative conclusion. For example, eradication of corruption, of course, as good as it gets, and makes sense for justice as fair for the case in question. This 4th element yields commensurate benefits as a corrupted state and affected civil society whose perception of justice is improved when and if courts' counteraction is proportional to crime, not only in terms of retribution, but other sanctioning, social justice sanctioning, that includes prevention. By it, a court demonstrates that the recovered assets should be shared with civil society, whether local or urban communities deprived of various amenities, for example, deficient health service, poor preschooling, policing, communication, transportation, and so on. The original rule of law problem may then be more constructively and viably countered in the next rounds through technical cooperation that may include other measures to be addressed by the relevant project stakeholders and actors. We do not need to call the shots because an average person may not care about the rule of law per se as per this official term, let alone about the tripartite division of powers with independent judiciary among them. It will be enough through social justice measures aiming at equity and equality to provide them as such, without naming them. This may be one of the ways to promote social progress and better standards of life in larger freedom, emphasized by the UN Charter and the Universal Declaration of Human Rights. So, from the famous thought experiment used by the UNODC module How to Train in Integrity, this upscale rule of law win-win example illustrates a contribution to a systemic reduction of inequalities. Ladies and gentlemen, since one picture equals 1,000 words, I would like to finish my talk with this Yangian, yes, in this order. Yang as the active principle, yin as the receptive principle, both dynamic interrelated. At the 51st session, the Human Rights Council debated whether or not South-South human rights cooperation and technical assistance would also involve assistance to developed countries, not only to developing countries. Reportedly, the discussion showed that they also could receive assistance and learn from the positive experiences of other nations. I worked in the part of the UN program dealing with crime prevention and criminal justice, which adopted 20 years ago the whole idea of restorative justice through the ECOSOC resolution 2002/12. The idea originally based on indigenous justice practices which survived in Canada, but elsewhere as well, that is in the global south countries that have been there in the order of the day. Moreover, the 2030 Sustainable Development Agenda carries the recommendation of living in harmony with nature. So, to me, the Chinese yang, the active principle, has been factored into the agenda from a developing world. And since there is a documented consensus on the rule of law for the protection of human rights, there should be more work done in operationalizing that consensus in the way in which the Universal Declaration of Human Rights calls us. If we want to live in harmony with nature, we should go back to its human roots. That's why I tried to do so in this win-win way in this author's talk. I hope this argument captures the approach to enhancing criminal justice through this UN win-win rule of law operational activities. In its vein, I tried to illustrate the benefits of just and fair technical cooperation to leave no one behind with the rule of law in its core. Ladies and gentlemen, the UN Charter, the Universal Declaration of Human Rights, the 2015 UN Declaration with Solidarity Principle, they have their own original social justice interpretation, and they very much deserve a more incisive implementation. Because of their Second World War roots, they all are without ideological libertarian or rightist bias, without hidden militancy or aggression. Militancy or aggression are both defined out by the UN Charter. In other words, we should not apply to the challenges involving the rule of law in a contemporary world, a contemporary cliche of liberalism, illiberalism, and populism, but see to the roots of the UN. So what now a technical assistance rule of law provider can do is to start addressing the UN solidarity principle constructively by really putting oneself in the shoes of a recipient of that assistance, and both can advance the rule of law as first proclaimed by the Universal Declaration, or as we should see the problem as a bare-bone justice needs assessment. Alternatively, paraphrasing Mitchell Sharp, by enhancing operational activities and technical assistance for criminal justice and crime prevention, we may get anything what we want, but we will also end up with what we deserve. So now comes the time for conclusions and hopefully questions and answers. First, on people with positions of authority and responsibility governmental officials, lawyers, judges, educators, CEOs, other business persons, trainers, etc., rest the obligation to benefit those who are in the worst social situation, for example, the disabled, the homeless, prisoners, migrants, or refugees. It is in those high-ups' vested interest to care for those left behind, to give them a chance. For, ladies and gentlemen, for, if they were left behind, would not they then have needed people with positions of authority or responsibility to take good care of them and lift them up from material and intellectual poverty, from trouble? Would not this be to a mutual advantage? Second, the UN solidarity principle suggests that win-win should be a rudimentary or elementary strategy to pursue it effectively in the name of the rule of law among and within countries. Third, as obvious in SDG technical assistance preparation and implementation are economic intelligence methods like Gini coefficient of income dispersion or the Palma ratio of income concentration, defined as the ratio of richest 10% of the population's share of gross national income divided by the poorest 40% of the population share. Likewise, useful should become pursuing that goal as a solidarity principle orchestrated by the social justice intelligence difference principle. So indeed, those left behind will be better off and motivated to act in their own rule of law favor. Fourth, the UN Secretariat should update and upscale its guidance note on assistance for strengthening the rule of law at the international level, has been with the UNODC's involvement guiding the Secretariat and UN agencies in implementing the rule of law mandates. May we then receive in return what is needed in a genuine spirit of brotherhood for the sake of the advancement of the rule of law. Thank you very much.
Thank you, Sławomir, for that presentation. Colleagues, as I mentioned, if you would like to ask questions, we'd encourage you to use the chat. As a former UNODC staff member, who was working in the field doing technical assistance, how do you feel things have changed concretely in terms of how our technical assistance programs are, drawing from your own experience?
Well, thank you for this question, Giovanna. I can only reply to your question in my own personal or my personal experience terms, because of the development of the UN crime program. Not of the UN drugs program that started technical assistance much earlier than the UN crime program. I was among the first colleagues from the UN crime prevention and criminal justice program who served in the field. While the colleagues from the parallel program of the drugs have been there in the field for at least, I think, 15 years longer, or maybe 2 decades longer. So my first experience concerning the role of crime prevention and criminal justice was driven by the very simple development, very simple, if I may say so, but extremely salient, I would say, development in the UN crime program, namely the adoption of the United Nations Convention Against Transnational Organized Crime. When that convention was adopted, so it was and then signed, but it still was not ratified. It still was not ratified. The first encounters of with technical assistance emerged within the UN crime program, because it was the so-called pre-ratification assistance for countries planning to join UNTOC. So, but at the same time, when being in the field, we had quite an experience of our more experienced colleagues from drugs. So I was sort of, watching from my crime and criminal justice side what they are doing. However, and I must say very plainly, what always struck me over these years, and even now, concerning the developments in technical assistance in the United Nations program, and maybe also outside that program, is the overwhelming emphasis on criminal justice issues, and with some, I would say, less emphasis on crime prevention issues. Prevention in the UN, even though it was the conflict prevention that was started to be emphasized because of peacekeeping developments in the UN that started really in the second half of 1990s, it was always the second part of the UN job, and even less, at least until the first mission to Bosnia and Herzegovina in 1992 was the question of the rule of law. So I think that the whole development, if really makes sense for for sustainable development, in that development, the questions and the approach, the preventive approach, the social justice approach, and combined with the rule of law approach, is the way really to keep us going in the right direction. That's the only thing that seems to me, especially in the current world, so important, that we should really emphasize not only this control side, which is absolutely legitimate and which is absolutely needed. It has to be strengthened and enhanced, but at the same time, this other part of prevention, of social justice, of going into the field with an idea that this makes sense for the rule of law. It does not make sense only for the prevention of drugs or for crime prevention, but for the rule of law. That may be in this, maybe the ingredient built into a program concerning, kindergarten, preschool education, and of course civil society education at levels. And of course the UNODC is doing this because it has now the Education for Justice and other programs that are so important, and the culture of lawfulness that is also an umbrella concept for all what we are talking about. But I would really like to see it not only for the university students, that we go really to the postgraduates with the same thing. So what I was trying to say today is exactly this. What about really moving into the field? This is what we teach at the tertiary level, the students and of course younger ones in other terms and concepts.
Thank you for that. Also, just interesting to hear you were a pioneer in a sense of delivering the first of the technical assistance programs for UNODC for the crime side. We have a question in the chat. Delivering rule of law technical assistance is complex and obstacle-ridden process, very often politically sensitive. What structural changes should take place to ensure that the UN system is fit for purpose and reaches long-term sustainable results?
It's a very, very important question. I think that the beauty of the work that the UNODC is doing, both in terms of drugs and crimes and crime prevention, is that these challenges that you speak about, the intricacies, delicacies, and controversies over the implementation of certain concepts and objectives of the UN Charter can be overcome by making this as a technical problem. And I think that the UNODC has one of the greatest successes by making in a professional and technical way the intricacies of the United Nations Charter and the United Nations Crime Prevention, Criminal Justice, human rights instruments to be so important for security of a person and for the right to life of a person, that nobody thinks about the concerns regarding the interpretation of this or that right. And the way that one is able to convince that this is really a problem, crime prevention and criminal justice problem, and the need of that approach is important, makes the program or the project running. That's why I said in my statement that you don't have to call everything this is against the rule of law. In a sense, that you call the shots. In my native country, which is also the rule of law is at the agenda. The lawyers who are discussing the questions of the rule of law and of the independence of judiciary and regarding the importance of the Constitution hardly use the scientific, academic, scholarly terms, coming to the field, coming to the community, coming to people who simply in daily life simply are not used to such lofty concepts. And this works.
Thank you so much for that. Yeah, I think being accessible to a broader audience is really part of that. Are there any other questions, colleagues? We're just 2 minutes over time, but more or less. And our colleague thanks you for the interesting session, which it really was, Sławomir. I find your wealth of experience coupled with your academic critical thinking is just really refreshing to have those two things married, and to hear from you, and yeah, absolutely. Any ways that we can look to improve how we do things and improve the impact we have is welcome. So thank you so much, Sławomir.
Thank you.
And thank you, colleagues, for joining us.
Thank you.